So, getting bail is one of the most important rights in criminal law. It ensures that an accused person is not unnecessarily kept in jail before their guilt is proven. And recently, the Bharatiya Nagarik Suraksha Sanhita 2023 brought some major changes in how bail is granted, applied for, and processed. And in this video, we'll break down the new rules for bail under BSS in simple terms. Let's start with a very basic question. So, what is bail? When someone is arrested, they don't just sit in jail until their case is over. They usually get a chance to be released before the trial, which is called bail. Now, this doesn't mean they are found innocent, they are still accused, but it lets them go with some conditions. Like, for example, they might have to go back to court on certain days or promise not to destroy evidence or leave the country. And this way, bail keeps people from being punished before they've been proven guilty. It's a way to make sure that only those who really need to stay in jail do. Now, coming to the different types of bail under the BSS, it has two types of bail, bailable and non-bailable. Now, this is just like the CrPC. Bailable offenses are crimes where the accused has a right to get bail. Think of it like a lighter crime, like maybe stealing something small. The accused in this case has a right to be released on bail. On the other hand, we have non-bailable offenses. These are more serious crimes. For example, murder or serious assault. Here, the accused doesn't automatically get bail. The court has to decide if they should be released or not. Next, let's talk about how bail works in practice. So for bailable offenses, under Section 167 of BSS, if someone is arrested for a bailable offense, they should be given bail as soon as possible. This could be done either by the police or a magistrate, and this usually happens right after the arrest. As for the non-bailable offenses, the rules are a bit different. Under Section 167 of the BSS, the court will look into a few things before deciding on bail. So first, the court looks at the nature of the crime. How serious is it? Then they consider the evidence against the accused. After that, they check the accused's past. Have they committed similar crimes before? And finally, they think about the possibility of the accused running away or harming the people involved in the case. If the court thinks that the accused might do that, they'll probably be less likely to get bail. And to make sure that the bail plea isn't delayed unnecessarily, the BSS talks about having time-bound hearings. That means there is a set amount of time that the court has to follow when making a decision about bail. What about the under trials and the poor accused? Well, the BSS wants to make sure that people who are in jail for a long time without a trial are treated fairly. This is especially important for those who cannot afford a lawyer or someone to stand as their surety, which is like a guarantee that the accused will show up for their court dates. The law now says that if someone has been in jail for half the maximum sentence for the crime they are accused of, they should be released on a personal bond or with very easy conditions. Another big change in the BSS is something called default bail. So remember how I said that if the court is considering a bail plea, they have to make a decision in a set amount of time? Well, if the police don't finish their investigation and file the right papers on time, the accused automatically gets bail. This is called default bail. The police have 60 days to file the charge sheet. If it's a less serious crime, and 90 days for more serious crimes. If they don't do it on time, and if they don't have a good reason for the delay, the court has to let the accused go. And finally, let's talk about the conditions for bail. So when someone is granted bail, the court might set some conditions for them. These conditions are meant to make sure that the accused understands that they need to follow the rules. Some examples include not talking to the witnesses in the case, giving up their passport so they can't leave the country, checking in with the police regularly, or going to court every time they're told to. If the accused breaks these conditions, the court can take away their bail and send them back to jail. The BSS encourages courts to use technology more to handle bail matters. This includes using e-courts and e-bail applications, especially in big cities. This way, the process becomes faster, there's less paperwork, and there's more transparency in the orders and timelines. It's possible that in the future, even bail bonds and sureties will be submitted online. And lastly, let's talk about canceling bail. So if the accused misuses their freedom, threatens witnesses, or commits another crime while they're out on bail, the court can take away their bail and order them to be arrested again. To conclude, the BSS brings in some positive changes. It makes the process of getting bail faster and fairer, especially for those who are not guilty. It also encourages courts to use technology more, which helps everyone involved. Overall, the goal of these changes is to reduce overcrowding in jails and protect the rights of people who might be innocent while also making sure that criminals are held accountable. If you found this video helpful, please leave a comment below to share your thoughts. We would love to hear from you. And if you haven't already, please subscribe and hit the bell icon to stay updated with our latest videos. Thanks for watching.